Hello RGL 2100 students, Dr. Conway here for a quick lecture video this time because enforcement practices are fairly straightforward. You should have already looked at the Compliance Promotion and Enforcement policy under CIPA as a classic example of the types of information that go into compliance promotion and enforcement. But let's take a quick look at the issue of enforcement, which is lesson 10, all right? So enforcement can be defined as the act of compelling adherence to legal obligations by employment of penalties, obviously. If compliance promotion is effective, which we've talked about many times, regulatory enforcement actions can and typically are relatively rare, all right? But when they do occur, often an example needs to be set, like we've seen with Volkswagen Dieselgate, for example. Regulatory enforcement has to go through due process, right? Because as we learned in the legislative basis of regulation, there are laws of general application, including the criminal law, which stipulates due process before the law. So most enforcement actions must adhere to due process under the law, as indicated in the criminal code, right? So regulatory enforcement, depending on the nature of the regulation, relies on regulatory scrutiny to gather evidence, including inspections on a random and responsive basis, gathering samples for testing, food, water quality, etc., organizing and assessing reporting data required under regulations, and those have to be stored in a certain way. They have to be maintained for a certain period of time, all consistent with due process before the courts, right? If an enforcement action needs to go to the courts. Organizing and assessing reporting data required under regulations. Monitoring of general conditions, all right? Lending practices, pricing practices, socioeconomic metrics, ambient environment, and that all relates to that whole issue of information in the regulatory process and how information is power. Taking action based on credible third-party information is also an option that can be taken place. All of this has to be meticulously maintained according to requirements of due process and requirements of evidence gathering and evidence storage, the chain of evidence, if you will. For any legal proceedings. The same thing applies to environmental enforcement or any other type of regulatory enforcement as it does to other criminal law proceedings, because the criminal code is in a law of general application that applies to any regulation within federal government or any government where penalties can be ascribed, right, for non-compliance, okay? And so effective regulatory organizations conduct these information gathering activities according to detailed enforcement plans. The court may ask for a detailed enforcement plan. Did you follow this? Was it consistent? Did you store evidence? Did you gather evidence properly? All of these kinds of things come into play. Enforcement plans usually reflect enforcement priorities as well. Scarcity and opportunity cost, right? You've learned about that in the past. There's only so much enforcement scrutiny that any organization can apply, so that needs to be prioritized. We talked about priority setting frameworks earlier in the course. We talked about the importance of that, right? So, you know, enforcement plans that are set out by regulatory agencies set out enforcement priorities. They do that by identifying historical problems, different groups in the regulated community that may be exposed. They might focus more on SMEs than the large guys that are already well advanced in regulatory compliance. They might focus on regional variability. Maybe in the past we're having problems in certain geographical zones where there's particular problems with loading of pollution into water bodies or whatever the case may be, among other factors. And so because of limited resources, they have to set out a clear enforcement plan. So the enforcement unit of any regulatory body will set out that plan and get it approved, because there are only so many resources to go around for enforcement. So the organization wants to target those enforcement activities on those areas that are of the greatest risk, right? And when regulatory violations warrant, enforcement officials in most governments typically undertake detailed investigations as well. So, you know, you set out a plan for how you do your enforcement scanning, right? much the way of a police department will do that, but then investigations will focus resources on particular violations that are deemed to be important. So the difference between ongoing enforcement scanning, which is a major part of what enforcement organizations do within regulatory bodies, right? But also then there's investigations which will focus much more intently on a particular problem. These investigations, right, as part of enforcement actions are typically done according to enforcement procedures that should be set out clearly for enforcement officials to be consistent with due process before the law, which is required by the law of general application, which is in this case criminal law. The courts will expect due process be followed, evidence be collected properly, there be a chain of evidence, right? A chain of control of evidence. Evidence is stored adequately for a given period of time. There's no reason to doubt the credibility of the evidence. And so the same thing that a detective in a police force would adhere to, same thing with an enforcement officer of a regulatory organization, okay? And for that reason, enforcement officers have their own track of training. We train as regulators, but actually enforcement officers have their own training program, a specialized training program, all right, on how to do enforcement, because they're quasi police in that sense, okay? Enforcement officials receive guidance, documents, and training on how to properly execute enforcement actions. Enforcement actions tend to move through steps that give the regulated party opportunities to come into compliance in a reasonable time frame, right? So we talked about that, right? Where regulators will often work with the enforcement officers to give a regulated party that's not in compliance time to come into compliance. And so if you're a regulatory affairs person working in a company and you're in that situation, you will end up working with the regulator and their enforcement arm to come up with a plan to bring the company back into compliance. And the government's always going to prefer that because of the risk of going to a full enforcement action. It's much better to bring a party into compliance by working with them in a reasonable time frame than to have to go to enforcement action, right? But sometimes you have to go to enforcement action. Okay, but they will try to work with regulated parties prior to the next step in the enforcement action, bringing them closer to penalties. All right. Once an enforcement action is started, there needs to be a clear resolution, however. So bringing a party back into compliance is preferred before an official enforcement action takes place, because once it's started, right, it has to be concluded one way or another. The party is innocent, or the party is going to be fined or charged, or there's going to be some penalty ascribed. Very much, again, same thing as criminal law, right? You know, they can only hold you so much for questioning before an enforcement action has to start. They have to charge you. And once they charge you, it has to be resolved, right? You have to be resolved as innocent or guilty. And it's that simple. It's very similar because the law of general application that we're referring to. There needs to be a clear resolution according to the enforcement rules of procedure, and that this outcome must be publicly known, very much like in criminal law, right? I mean, if somebody's charged and then released, that's on the books. I mean, that's public information, all right? So, I mean, it's very much the same thing. Enforcement generally includes the following types of steps. A verbal or written warning. This is when the process starts, like you're out of line, let's work together and try to bring you into line, right? Administrative directives or orders. So the minister might direct that, you know, this company must engage with the department on a plan to come into compliance. If that does not occur, right, then penalties may start, right? An enforcement action may start. There may be administratively imposed monetary penalties to start, which the minister has powers under legislation to do. So there might be a fine, right, that would ascribe. And if they still don't comply after the fine, right, then there may be other things that take place, like increased regulatory burden, more stringent reporting and inspection requirements can be imposed on the company. Then if that doesn't work, then there's injunctions, right? You may not be able to operate anymore, right? You may be injuncted from operations for a period of time until the situation is resolved, or until you can convince the regulator that the situation is going to be resolved, right? There could be licensing sanctions, increased restrictions and suspensions on operations, or you may be allowed to operate some part of your company but not the other, right, until the situation is wrong. Then there could be civil suits by the Crown to recover costs. The Crown could sue you the way they did with the Volkswagen with Dieselgate, right? The Crown could sort of, bring you before the court saying that the damage caused was such and such, and, polluter pays. You got to pay. And that can be, as we've seen with a lot of different lawsuits, can be with Volkswagen Dieselgate, can be in the tens and tens of billions of dollars, depending upon the nature of the issue, right? And then there's criminal prosecutions at the end. If we still have a problem after all of that, we still have a significant problem, and there can be criminal prosecutions. And we've seen that also with Volkswagen, right? Where members of the board of Volkswagen have been criminally charged and go to jail, all right? So it can be very serious, and that's why, at the end of all this, of environmental law or other type of regulatory law, people, can go to jail. So therefore, due process must be followed as according to a law of general application, which in this case is criminal law, right? Most institutions with substantial regulatory mandates will create separate enforcement units to oversee coordinated implementation of compliance and enforcement activities, okay? The enforcement guys at, for example, Environment Canada, they've got uniforms. They go out, they do inspections, and they are regulatory enforcement officers. That's what they do. And they receive unique training for that, right? These units will typically provide overall functional direction for investigations, inspections, and other enforcement actions, develop and monitor an annual inspection plan, which we talked about before, develop and enforce enforcement training courses. For example, Algonquin Colleges has a training program for enforcement officers, all right? Deliver training programs to inspections and investigators, develop and maintain management information systems relating to tracking, regulation, implementation, and so on. So that it's a different, and sometimes the compliance promotion officers will be the typical regulatory people. They're the people you call and they help you come into compliance. When there's a problem with compliance, that will shift to your enforcement arm, and the enforcement arm will run quasi-independent from the regulatory arm because of due process considerations and so on, right? So they will have their own leadership, and they will have their own way of being trained, and they will have their own way. And obviously enforcement officers who go and do inspections and all that are feeding information back into the regulation arm, right? In terms of the samples, inspections, any transgressions that were found, and all that feeds back into regulation. And then the regulatory body itself will get together and begin that process of written warnings and all of those things that we've talked about in the previous slide. And in the end, the enforcement arm then begins to look more and more like a police force, because it collects evidence, it stores evidence, it presents evidence, and if something goes to a full civil lawsuit or a full criminal prosecution, all that has to be in place, right? All that information and evidence has to be in place, because the way the court will interpret it as criminal law, right? That's why that's why I lecture on laws of general application. At that point, you're in criminal proceedings. So all the evidence you need to present has to have a record, a chain of evidence, has to be shown to be valid, credible, that it was collected according to the law, it was stored according to the law, it was all these things, okay, in order for the courts to be able to use that information in adjudication. Right, of any criminal proceedings. And so from very early on in the process, enforcement officers have to anticipate that it is good. If they find organizations not in compliance, they have to assume that at the end of the day, this could go all the way to criminal prosecution. So we have to start, following the rules of due process and evidentiary processes from the very beginning. Right? So everything has to be done according to a plan and consistent with due process under law. so that the courts can see that this was not prejudicial inspection, this was not unfair or unreasonable inspection. This was, all of those things have to be guarded against, and that's why organizations have to have a clear enforcement plan. It has to be consistent with a compliance, promotion, and enforcement policy. And the courts will see that all of this was laid out, all of this was clear. The regulated parties should have known their rights and obligations under these proceedings. Evidence was gathered in the right way. It was stored in the right way. It's presented in the right way. Reasonable conclusions were reached from the evidence, and so on, and so that the court can make a decision, either in a civil case or in a criminal case. All right, so. The enforcement arm of regulation is a different stream, okay? But obviously, the whole point of the enforcement arm is to reinforce the regulation, right? So the regulatory body within an organization will typically have a separate enforcement arm that specializes in those things, but they're the outreach arm of and the enforcement arm of the regulatory body, right? So they're feeding information back. They're doing all of those kinds of things with inspections, just as the monitoring people who doing water sample monitoring for the environment are also sort of a separate group, and they're feeding information into the regulatory body as well. Okay, so ultimately it all comes together so that the regulation can be seen in operation in the real world, right, with information being gathered. And this brings us full circle back to information being critically important at all stages of the regulatory life cycle, and that information is power in all of these proceedings. And we can see that really clearly in the case of enforcement, can't we? If information is poorly collected, not gathered properly, not stored properly, then that information becomes discredited in the enforcement proceedings, and the government risks losing its case, right? So all of those information requirements are set out typically in the training that enforcement officers get, in the guidance documents that enforcement officers receive, and all stemming from compliance, promotion, and enforcement policy of any regulatory set of regulations. Like I told you, to look at CEPA's compliance, promotion, and enforcement policy, and you will see how all that plays out. The relationship between compliance and enforcement, the relationship between the regulators, the regulatory designers, and information gatherers, and the enforcement arm. All of that becomes a little clearer when you read through one of those policy frameworks. All right? So on that score, I'll let you go. It's a relatively short lecture this time because the principle of enforcement is fairly clear-cut, and we don't go deep into enforcement actions, but do read compliance, promotion, and enforcement policy of CEPA as a good example. All right? Talk to you again next time. Bye-bye now.